Hello, and welcome to the Number 5 Planning Podcast. In this episode, we're considering the interaction between planning and forestry regimes, and the operation and application of the Forestry Act to land. I'm Scott Stemp, and joining me today are Jessica Allen and Daniel Henderson, Planning and Environmental Barristers at Number 5 Chambers. So why are we talking about forestry legislation? Well, it's going to be relevant to any site where felling of trees either has or will be started before the grant of planning permission for development of that site. And forestry legislation and notices issued under that legislation can cause very real complications and headaches for site development. Indeed, the interaction of forestry and planning regimes has been the subject of a number of recent court judgments. With that in mind, let's turn first to forestry legislation. Now, broadly, this requires a licence to be obtained for the felling of trees over a minimum volume of timber. That licence might come with conditions to restock the land with trees and to maintain them. Felling trees without a felling licence is both a criminal offence and might trigger the issue of a restocking notice from the Commission requiring replanting and maintenance of trees. But one of the first questions is, well, does this apply to all trees?
The short answer is no, and as you've hinted at, Scott, there are quite a lot of exceptions and exemptions within the legislation to that general rule. And we're not going to cover them all here because we'll be here until next week. There are quite a lot, and some of them are extremely specific. But what I'm going to go and do is have a look at 5 of the more important ones, starting with what might be the most important, or at least most obvious, which is the fact that that starting point only applies to trees which are growing. Not strictly an exemption per se, but it is important. There is no need to get a felling licence for trees which are not growing or which are dead. That sounds like a straightforward enough point. It can cause difficulties, principally in circumstances where there is a lack of evidence about whether particular trees were or were not growing at the point at which they are felled. So while that seems a straightforward enough principle, it's not going to be the first time in this podcast, I suspect, that you will hear one of us say, it is vitally important to ensure that the contractor who is carrying out the felling at the time takes very careful note and very careful evidence of the position of the trees that are being felled at that time. So that's the first. The second is diameter. This is also an important exemption. In short, you do not need a felling licence for certain smaller trees, and what's defined as smaller is measured by diameter. There are really 2 sub-exemptions here. You don't need a licence at all to fell any tree that's got a diameter of under 8 centimetres, or in the case of underwood, 15 centimetres. And the second is that if you are the occupier or tenant of a parcel of land, you're permitted to fell trees that are a little bit larger, up to 10 centimetres in diameter, so long as you're doing so for the purpose of the growth of other trees. That's what the legislation says, which is effectively code for thinning. Probably important to note on that second sub-exemption that the Forestry Commission have an internal policy, which suggests that you're only allowed to apply this exemption in respect of up to 30% of trees in any given area. That, again, another running theme, is not something that's reflected in the legislation, but it is a policy that the Commission are rather keen on. And we'll hear Jess talk in a little bit more detail yesterday about some of the problems the Forestry Commission have run into in that regard. Third important exemption, about which is important to say a little bit more, is the fruit trees, orchard garden, churchyard and public open space exemption. This is an unhelpfully worded exception because despite being contained in one subsection of the Forestry Act, they are quite discrete. Fruit trees are excluded altogether. You do not need a licence to fell fruit trees, but separate from that are trees which are contained on, in the wording of the legislation, land which is comprised in an orchard, garden, churchyard or public open space. Now, there is quite clearly room for disagreement about what constitutes a garden, or indeed some of those other definitions too. None are defined terms, but there's quite a lot of case law that's sprung up in the last 20 years or so about what one can properly call a garden, which is probably useful just to highlight, not only because it applies, or there's no reason that it shouldn't apply to words other than garden within that exception, but also because it's interesting just to see how these notices can work. 3 cases just to highlight. The first is a case called McKinney, which we can put the reference for in some notes that we'll send out with the podcast. McKinney was a case about land which had been a garden, historically, but had fallen into disuse and become overgrown. The developer set about felling it and claimed that that wasn't unlawful because it was felling on what was historically a garden. The magistrates' court agreed, but the High Court didn't. And the High Court concluded that the key question is what needs to be looked at is the state of the land at the time of the felling. So whether something was or was not historically a garden is relevant, but not determinative of the question. That principle was moved on a little bit in a case that's now become quite famous called Rockall. Again, the citation we can put in the notes. Again, concerned land which was historically a garden, but the relevant landowner had moved to New Zealand and so was not in a position to maintain the land, and it had become very overgrown in the meantime. Sometime later, Mr. Rockall, who purchased the land, felled the trees, having told the Commission that he intended to restore it to what his words I think was parkland. So he'd actively gone to the Forestry Commission and said that that was his intention. The Commission weren't terribly interested in that and prosecuted him for felling the trees, and he was convicted. His appeal to the High Court was allowed on the basis that, while a mere statement of intent to recultivate land as a garden probably isn't enough to claim that it is, at the point you fell the trees, a garden, if you have clearly evidenced an intention to recultivate that land as a garden, that could be enough. And in this case, they concluded that because Mr. Rockall had actually gone straight to the Commission and said, "This is my plan," that was sufficient. That's again been reconsidered in a case called Wickford, which Jess is going to talk about in much more detail, but I'm going to jump the gun and talk about it a little bit here because it is relevant. In Wickford, not dissimilar to Rockall, or so the claimant said, they had commissioned a wood management plan, which they attempted to use as evidence of an intention to recultivate as a garden. The Secretary of State disagreed, and the High Court, on appeal, dismissed the challenge to that, in part because of the way in which the decision letter was framed, but also because the High Court cast quite considerable doubt on the reasoning in Rockall. They effectively said, or Mrs. Justice Leven said, that the focus of the legislation is on what the piece of land is at the time of felling. And by definition, an intent to turn it into something else is a future aspiration. It is not a description of where we are at present. So the position as we are now, with that exception, gardens and all of the other exemptions within Section 92B are to be adjudicated against the position as they stand now. And intention is relevant, but limited.
So that throws up an interesting question in relation to gardens, and particularly in the context of something that's very popular elsewhere in a slightly different context, which is this idea of rewilding. So when we're considering the garden exemption, presumably we're not limited only to areas which are cultivated, mown, kept in a tidy way for the growing of flowers and vegetables. Presumably garden has some wider reaching implication.
That's absolutely right. It certainly does. So I think this was another point that came up in Rockall and the judgment of Lord Justice Moses, who discusses in slightly pejorative terms the gardens of North London, or land in the back streets of North London, which he described, I think, as hardly worth bothering to cultivate. But it's making an important point, which is precisely that, yes, you don't have to have a perfect English country garden or a croquet lawn of a garden in order for it to count as a garden. It's always going to be a very fact-specific question, and much of it will depend on use. But absolutely right to observe that it's not simply a case of planting some nice roses and being over the hill on that one.
So presumably, picking up on what you were saying before, again, when we're thinking about our position in relation to the felling of trees and use of land as a garden or not, again, evidence is going to be vital.
Absolutely critical. Yes, absolutely critical. And often evidence, the easiest evidence to establish often will be historic use, but current, past, present use can all be relevant to the question.
Thank you.
The fourth important exemption we should talk about is to do with the prevention of danger or the abatement of nuisance. It's again really important to treat these separately, even though the Forestry Act lumps them together. Where works, i.e. felling, are necessary to prevent danger, you are going to need very strong contemporaneous evidence of a real and appreciable danger. There will be plenty of situations, no doubt, where people can be concerned and have certain anxieties about a tree with dubious structural integrity. But that's not going to be enough. If you're going to rely on this exemption, it's really important that you ascertain at the time of felling precisely what the danger is, precisely the level of risk, and to record all of that very, very clearly, because you will need clear and appreciable evidence that there is a danger. Slightly different with a nuisance. You are perfectly entitled to fell trees that are causative of a nuisance. Often that arises in the context of encroachment. There isn't the same need to show urgency or immediacy, but again, if you're relying on an exemption of this kind, it's still absolutely essential to document the nature of the nuisance and its extent at the point that you fell, because it's going to be very, very difficult after the fact to recreate that situation for the purposes of the appeal process that we'll talk about in a minute. And then the fifth exemption, which I'm just going to refer to briefly, but which Jess will talk about in more detail, is relating to planning permission. Suffice it to say, for my purposes, or for present purposes, the felling must be, in order to benefit from this exemption, immediately required for the purpose of carrying out development authorised by planning permission. And the Court of Appeal in a case called Arnold White, and the High Court in Wickford, to which I referred earlier, has given us a lot more detail about what that actually means. But the centrally relevant point is that the permission must be in place first. You're not able to use it retrospectively to justify felling, for example, to clear a site for survey work or anything of that nature. So those are the most important exceptions to look at for the time being.
And I suppose looking at those exceptions, some of them you might have trees which maybe sit across a number of categories, for example, fruit trees in an orchard, and others where you may have standalone contributions. There's a minimum threshold for volumes of timber to count towards whether a license is required or not. And that, I think, is 5 cubic meters per quarter, provided you're not selling more than 2 cubic meters per quarter. It might be difficult to visualize, but 5 cubic meters on the ground doesn't actually amount to terribly much timber once you start cutting down perhaps sometimes sizable trees. But these exemptions that we've been talking about, they presumably are cumulative with each other, are they?
They are, yes. So the 5 cubic metre exemption is exclusive of those caught by other exemptions. So were you to cut down a whole range of trees of a very small diameter, and also to cut down fewer than 5 cubic metres of trees of a larger diameter, you would be all right, notwithstanding that you'd end up with probably substantially more timber than that 5 cubic metres.
So we're looking at 5 cubic metres of what we might call qualifying timber.
Precisely that, yes, precisely that.
So what happens then if we hit a situation where we have a site where we hope for or are in the process of obtaining a planning permission, and Jess will talk to us about that a bit in a moment, but we don't quite have it yet. Off we go, start undertaking some clearance work, maybe getting ready for surveys, and we have, unfortunately, cut down more than 5 cubic metres of qualifying timber. What are we likely to face by way of action or prospects?
What we are most likely to face in that most unfortunate of situations is something called a restocking notice. That is the most common enforcement measure that the Forestry Commission are going to turn to, largely because its principle is that the land is restored with more trees. Section 17A is the power now used to issue restocking notices. It's as a result of Section 17A that restocking notices are now the first port of call. The old system was that you had to be prosecuted and convicted of an offence under Section 17 before a notice could be issued. Now, the Commission will simply issue a notice not straight away, but prior to prosecuting in all but the worst cases. Basically, a restocking notice is a notice that requires you to restock the land that you have felled on with trees. The important thing to notice about that, though, and Jess will discuss this in due course because it was relevant in Wickford, is that this is another area in which the Commission's guidance is not entirely reflective of the statutory scheme. The restocking notice will, in almost all cases, provide you with a number of trees to restock that is not reflective of the number you actually cut down, but reflective of the size of your land. And the number of trees that you're required to replant is calculated according to a formula relating to the size of your land. So for the purposes of the restocking notice, and this is why it's so important to get the felling right in the first place, because they can be extremely onerous, the Forestry Commission is not concerned necessarily with whether you felled 1 tree or 100 trees. What it's concerned with is that you restock the land according to a number of trees proportionate to the size of the land. There is a right of appeal, and that is important under Section 17B of the 1967 Act. An appeal against a restocking notice formally goes to the Department for Environment, Food and Rural Affairs, but in substance and in form will appear very much like an informal hearing in a planning appeal before something called a reference committee. It is what lawyers call de novo. That is to say, it's a full reconsideration of the decision to issue a notice on its merits. So when you're appealing, it's not necessary to identify some issue in the way the Commission has approached things. It's a full rehearing of the merits. And so if you are relying on an exemption, that exemption will be assessed in full with evidence by way of hearing. There are fairly strict procedural requirements, which are not necessarily reflective of the speed at which the process then unfolds. You need to appeal within 3 months, and when you appeal, you need to use something called a Form 6A. Once you get to appeal, most of the time, these appeals will be dealt with within a day. There'll be a site visit where the reference committee will go and have a look at the site in question, and then an informal hearing, which will be conducted on a sort of topic by topic basis, led by the reference committee. If you are relying on an exemption, depending on the technicality of that exemption, you will probably want to call evidence, professional or lay evidence, and the committee will assess the exception and then produce a report for the minister. The minister then may take, experience suggests, some time to produce a final decision. It is not a swift process. It often takes a number of months to get a decision, and often, at least until potentially very recently, when you do get a decision, you may not get much by way of reasoning for that decision until very recently, and potentially still. You get a decision that simply says your appeal has been dismissed. There are changes afoot, so watch this space on that. But I think the ultimate point to remember, to tie everything we've been talking about together, is that the burden will be on the appellant at an appeal to show on the balance of probabilities that an exemption applies. And that's why it's so important to get it right, evidentially in the first place, to take a careful note of everything that you're doing when you are felling. Because at the end of the day, if a notice is issued, it's going to be on you to show to the reference committee and to the Secretary of State in due course that you followed all the rules.
Now, just to pick up on one of those points, you mentioned earlier that the process and the hearing itself in broad structure will be familiar to those who have engaged in planning appeals by way of hearing, and obviously the need for evidence being vital. So there's a process, is there, of exchange of effectively what would be a hearing statement in a planning context, a statement of case, the grounds, the evidence supporting the same between you as the objector and the Forestry Commission as the issuer of the notice, which is then the subject of that led discussion before the reference committee.
There is, yes, absolutely. So again, in that respect, it's very much like a planning appeal. The appellant will put forward their case with their evidence, technical evidence if needs be, and the Forestry Commission, which, as you say, will almost always defend these appeals, not least because they are, as we say, de novo appeals. They are full reassessments of the merits, will then serve any evidence that they have in reply, and that will very commonly come by way of reports written at the time detailing what their surveyors and assessors and officers have gone out and observed on site with photographic evidence. And that's a point worth making because, again, you can generally be sure that the Commission will have taken their evidential requirements and responsibilities relatively professionally, because that's very much their job. Their officers are very used to dealing with cases like this. And so they will know precisely what they're looking for. And that makes it all the more important that you get out ahead in the first instance as a developer and make sure that you're solid on your evidence before you get that far.
Yes. Now, Jess, I think, is going to talk to us about some recent case law on the interaction between planning and forestry regimes. Just before I ask her to tell us about what's been going on, just to finish off with the restocking notice and the appeals. Restocking notices, I think, are time limited in duration, but aren't short.
Yes, that's right. And that's another part of the problem with the appeal process, is that it can take a very considerable amount of time to get anywhere. And the notices themselves can also last for a very significant amount of time. And that's why, as you said at the start, they can be very significant obstacles to development. Do not expect anything about this process to be swift if you get stuck within it. And that's why, yet again, to sound like a broken record, it's better to get it right in the first instance.
So there we are. We've got our restocking notice. We're thinking about an appeal because we are looking down the barrel of perhaps 10 years of worth of restocking and maintaining trees. Jessica, help us understand, what have the courts had to say about how that forestry regime interacts with or affects our prospects of getting or building out planning permissions?
Thank you, Scott and Daniel. Yes, so there have been in the past couple of years a few cases now that have considered this question. And really, we need to trace it back first to the decision in Arnold White Estates Limited and the Forestry Commission, which is a Court of Appeal decision from 2022. That decision concerned an outline planning permission that was obtained by Arnold White, and that was for mixed-use development on land. And they then proceeded to obtain a felling license, which was subject to restocking conditions. But what happened, as has been alluded to, and is not uncommon, is that trees were felled before reserved matters approval was obtained. Now, Arnold White, having obtained its reserved matters approval later, didn't comply with the restocking conditions on the licence. And the result was that the Forestry Commission served a Section 24 notice to enforce compliance. It's a slightly different notice to the restocking notice, but the purpose of the notice was to ensure compliance with the restocking notice already issued. Now, Arnold White sought the withdrawal of that Section 24 notice on the basis that it said the grant of full planning permission subsequent to the restocking notice in effect overrode the felling licence or the conditions on it, and there was no longer any need to comply with the restocking requirement. And secondly, that any refusal not to withdraw the notice, so effectively refusing to withdraw the notice, that would be irrational because it would prevent the development of the land in accordance with this now full planning permission or with reserve matters for a period of 10 years. Now, the Forestry Commission's response to that was, firstly, it said, well, we don't have the power in the legislation to amend or withdraw a notice, a Section 24 notice once it's issued. So that was its first answer. But secondly, it said that a planning permission can't be acted upon if to do so would make it impossible to comply with conditions on a Section 24 notice. So there we see that immediate tension here between the planning regime, a planning permission authorising Arnold White to carry out development, and a restocking notice and a subsequent Section 24 notice saying, no, you have to restock trees on that land that you're looking to develop. And the third point that the Forestry Commission said is that the planning permission didn't remove the requirements of an extant and implemented felling licence. So again, it took the view that the licensing regime was not overridden by the planning regime here. And just to touch on what Daniel mentioned earlier in terms of the exceptions, we're in the territory here of a question that arose about whether or not this was actually caught within the exception. I think it was agreed that it was not, but that was something that became clarified through the proceedings, certainly, because what happened was the claim for judicial review that was brought by Arnold White was dismissed, but then permission to appeal was granted on 3 grounds, and one of those grounds concerned the lawfulness of the decision to maintain the Section 24 notice. Now, the key guidance that came out of the court's reasoning on that ground is as follows. Firstly, that the exemption relating to planning permission does not provide an exemption from the requirement to obtain a felling licence solely on the basis of the outline planning permission. So the court made very clear that the grant of an outline planning permission as the first stage in a multi-stage process was insufficient for felling to be, as Daniel explained, immediately required, using the language of the legislation, to enable development authorised by a planning permission to be carried out. The court also indicated that Parliament had expressly provided in the Forestry Act for the interrelationship of the planning system and the legislation for forestry as fully as it considered necessary for the different scenarios that might arise. It noted that there was no provision elsewhere in the Forestry Act which had the effect of disapplying the statutory provisions for felling licences or conditions imposed on them where planning permission is subsequently obtained, and it found that there was no basis for reading any such provisions in effect into the legislation. A third point that the court made very clear is that there is no legislative hierarchy in which the planning system ranks above or takes precedent over the legislation for forestry. They comprise separate but coordinated statutory schemes. And that really went to the argument that was being levelled that effectively the grant of planning permission overrode the felling licence. The court said, no, that is not the case. And finally, on the question, just to touch on it, that related to actually whether the Forestry Commission had the power to revoke its Section 24 notice, the court actually didn't have to determine that issue. But again, looking to what Parliament's intention was in the scheme as a whole, there was doubt expressed that any such power existed, which may be contrasted with other powers that are referred to in the legislation. So just to note here then that there's already been some quite helpful and clear guidance on the relationship between the planning regime and the forestry licensing regime from the Court of Appeal. The court's consideration of the issues was strictly obiter, but because it had granted the appeal on other grounds by the time it came to deal with this third ground. But it was described as a carefully considered and full judgment given by a judge with enormous experience in the planning field, that judge being, of course, Lord Justice Lindblom. And it was given maximum weight in the decision to which Daniel's already referred, and I'll just go on to refer to next, which is the High Court decision that we had come out this year in July. It was the hearing of three conjoined cases, those being Witham Nelson, Wickford, that Daniel mentioned, and Smar Holdings. And all of those raised novel issues around the interrelationship between these two regimes. Wickford has already been touched on, and the only thing I would add to the points that Daniel mentioned on that case is the point that when Daniel was obviously telling us about the Forestry Commission's use of a standard restocking density when it's looking at what will be the number of trees that are required to be restocked. In the Wickford case, I think it was 9 trees that had been felled, but in applying the Forestry Commission's its own calculation, it required 242 trees to be restocked. I understand, having spoken to some others, that part of the reason behind this, the way this can work, is that trees can fail quite often. And so it is the case that, in fact, more trees may be required to be restocked because, in fact, in the longer term, several of those won't take. And overall, what the Forestry Commission is striving for is at least the same number of trees as have been removed. Now, in Wickford, that approach was challenged. Essentially, it was a rationality challenge, but the court accepted that the approach was rational and it was a matter that was well within their statutory discretion and professional judgment. The court did note that there may be a concern if in an extreme case the Forestry Commission applies its formula in circumstances where perhaps there's one sole tree in the middle of a field and actually the consequence is 100 trees are required to be restocked across the whole field such that it's effectively useless. But that wasn't considered to be sufficient in the circumstances of this case, at least, for the court to speculate as to when and if that might arise. So that's really picking up, I suppose, the only point we haven't actually touched on in Wickford, because Wickford didn't really, it raised novel issues about the licensing regime, but Smar and Witham Nelson are really the two that actually raised grounds of challenge that directly linked to the planning regime and the interrelationship between the two. So in Witham Nelson, the circumstances were that Witham Nelson had purchased land with the intention of obtaining planning permission and developing it for houses, and an arboriculture report was prepared and submitted to the local planning authority as part of the application for outline planning permission. That was then granted, and the permission specified that the retention of all the trees in the arboriculture report was a priority and desirable. What happened was that management agents for Witham Nelson subsequently procured services from an arboricultural company to clear foliage at the site, is what they said. But the consequence was that actually a number of the trees identified for felling were in fact felled. And similarly to Arnold White, full permission followed. It was after the felling that full planning permission was granted. So what happened was the Forestry Commission got wind of this and issued a restocking notice on Witham Nelson. And there was some early conversations between the parties about what should happen. And, you know, in that conversation, I believe Witham Nelson had informed the Forestry Commission, you know, that planning permission had now been granted. And they sought to agree a proposal with the Forestry Commission for restocking trees and alternative land, and that is an option under the legislation. It doesn't have to be restocked on the land where the trees are felled. The purpose of that proposal really was to ensure that trees would be maintained long term, because of course there's the immediate inconvenience that the land cannot be restocked in the period when these trees are required to be maintained. The standard period of that is 10 years. I think that is the maximum, and it is the standard one that we tend to see. And of course, it's inconvenient perhaps to wait for that period to expire. But when that period does expire, supposing there is an extant planning permission at that time, then it would be open to a developer to clear those trees again. So the purpose here was Witham Nelson seeking to pose an alternative area of land for restocking so that effectively both objectives could be achieved. We could carry out the development in line with the planning permission, and we could ensure that trees will actually be maintained in the long term. But Witham Nelson was subsequently issued with a final restocking notice, and that required the restocking of 330 trees on the land, again for this standard 10-year period. So Witham Nelson, maintaining that the trees hadn't been intentionally felled, appealed the restocking notice. They raised an argument about the service of the notice. They said it wasn't lawful because full planning permission had been granted. And they also said that it wasn't a reasonable or proportionate response. Now, as Daniel explained, what happened next was this went before a reference committee. And the reference committee acknowledged the unusual circumstances of this case, noting that any of the restocked trees will inevitably be removed once the legal obligation for maintenance expired. And the reference committee considered, therefore, that could nullify any of the advantages of the restocking beyond that period. But it nevertheless concluded that whilst every effort can be and should be made to ensure restocking notices are resilient to future circumstances, that could not be a determining factor in whether a restocking notice is appropriate or not. What's material, it said, are the circumstances at the time of felling and the silvicultural status of the site. Now, on the question then of whether the service of the notice was lawful following the grant of permission, the reference committee's response was a bit odd. It actually said this is a point of law, and that's better considered by way of judicial review. So we're not going to deal with that. We aren't lawyers. We don't have our own lawyers with us in this meeting, and so we're going to leave that issue. The reference committee then separately noted that it had considered the question of whether restocking an alternative site may be specifically appropriate. In this case, of course, Witham Nelson had already asked them, or had not asked them, but asked for the Forestry Commission for that to be agreed. But in this case, the reference committee considered it too. But again, sort of deferred that question and expressly deferred that to the minister to whom the report was going to be sent. And then what happened is the minister ultimately decided to uphold the restocking notice and decided against permitting the trees to be restocked. So that was when we got to court, because Witham Nelson raised 3 grounds of challenge against the minister's decision to uphold the notice. The first of those is that it was irrational, it said, for the minister to uphold the restocking notice, where it had been accepted by the reference committee that it was, quote, inevitable that the replanted trees would be removed. Now, the period for maintenance of the trees was reduced slightly, actually, in the appeal process. It was reduced from 10 years to 6.5 years. And that in part reflects what Scott and Daniel have mentioned about the duration of how long these proceedings can last, because this was around the time of COVID. And so that added even further delay. And so effectively, the period was reduced in recognition of the fact that there was already such a long period where appeal proceedings were ongoing. So it is now required for 6.5 years. And it was submitted based on the finding of the reference committee that it would be inevitable that the trees were removed, that there was therefore little or no silvicultural benefit to restocking in those circumstances. Of course, rationality is a very high bar in judicial review, but the court accepted that it was open to the reference committee and the minister to conclude that even 6.5 years growth could justify a restocking notice in view of the potential precedent effect that the holder of a licence could avoid the obligations by a subsequent grant of planning permission. However, the court then said, well, although that might be so, the balance shifted when the potential for other alternative land was taken into account. Ground 2 was that the reference committee fell into error by not addressing the alternative land issue themselves, and the minister did not remedy that error because she accepted an ex post facto submission effectively by the Forestry Commission that it would not consider an alternative area. So there was some further correspondence where, in effect, the Forestry Commission said they wouldn't agree to there being restocking on an alternative area of land. And so that was deemed to be the basis for not then pursuing that. And William Nelson therefore said that whether the restocking notice should be amended to refer to alternative land was a material consideration, and on the facts it was the only rational conclusion. And its third ground, I'll turn to the decision shortly, but the third ground was then, in summary, that the reference committee was wrong to determine the points of law, namely the implications of the grant of the full planning permission before service of the restocking notice. As a matter of statutory construction, the court held that the relevant provision of the Forestry Act, which provides for the possibility that trees can be restocked on alternative land, that provision is section 17A, 1AA of the Forestry Act. But that provision, the court said, placed no preference between restocking notice on the original land or such other land as may be agreed. And also the court said that there was no exceptionality test on either ordering or agreeing that the restocking notice should be applied to alternative land. And that really goes to something that arose in the SMAR case. But in essence, it had been suggested that because the legislation refers to the agreement of the Forestry Commission, the Forestry Commission had adopted an approach that, in fact, it would only agree if there was some act of God or extreme circumstance which justified restocking on alternative land. But here the court was saying there's no exceptionality test, there's no preference, and so it is simply a provision in the statutory scheme. And taking the first and second of those grounds together, the judge, Mrs. Justice Leaven, identified two legal errors. She said, firstly, there was no rational basis in this case on which to reject the possibility of alternative land where it could provide materially higher silvicultural benefits. And secondly, she said that insofar as the reference committee was concerned by the potential precedent effect of varying the restocking notice to include alternative land, it was not rationally possible to discern why that would be a material consideration, where the silvicultural benefit of the restocking notice relating to alternative land is greater than on the original land. And even if that were lawful, on the facts of the case, there was no expert opinion on the suitability of alternative land. It was simply rejected as a matter of principle. Finally, on the issue of the minister delegating, in effect, consideration of alternative land to the Forestry Commission, that was not an option open to the minister. And whilst the provision referred to alternative land being agreed with the Forestry Commission, as I've mentioned, it was open to the minister, so said the court, to order that the restocking notice be modified to refer to alternative land. And that power was under section 17B2. Finally, on the very specific issue in the third ground, the court held that the reference committee was wrong to decline to deal with an issue by saying it is a matter for judicial review. The court was quite concerned with that line of response and made clear that, of course, as a body, it has to make lawful decisions. And if it considered that there were points raised that it didn't have the legal knowledge on or needed legal advice on, that was something that they should have sought advice from lawyers about, or they should have referred the matter to the minister. But what they shouldn't have done is simply decline to deal with it. And then just moving on to the SMAR case. So in SMAR had began felling trees on land which formed part of an emerging housing allocation in the Bristol City Council local plan review without a felling licence or a planning permission. So quite different in that sense from Arnold White and from William Nelson. The Forestry Commission became aware of the felling, as often it does, and must have been tipped off, and it carried out several site visits, after which it discovered that over 53 metres cubed of timber had been felled. None of the statutory exceptions that Daniel's mentioned applied, and so the Forestry Commission served a restocking notice on SMAR, which included a standard requirement, as we've said, that the restocked trees be maintained for 10 years. SMAR, as the others in this case, appealed the restocking notice. It was argued there that the conditions should be varied to allow redevelopment of part of the land for housing within the next 10 years, if so required. So essentially introducing a conditionality element to that maintenance requirement. Alternatively, that restocking should be allowed to take place on alternative land. The intention in seeking those two options was to reflect the position of the exemption that Daniel mentioned, effectively the planning permission exemption. So at which point that SMAR gets planning permission, the conditions of the restocking notice would effectively allow them either to cut down the trees earlier than 10 years, or alternatively, they've managed to have it agreed that the trees are on alternative land and they can crack on. Again, the appeal went before the reference committee, and the reference committee determined in this case, on this appeal, it found firstly that modifying the maintenance period as proposed would undermine both the felling licence regime and the planning regime, and that it was not for them to determine the primacy of the public interest in replacing felled trees or the public interest in housing development. Secondly, the reference committee said that the possibility of land being allocated for development could not justify restocking elsewhere, as again, the Forestry Commission had advised them that it would only agree to restocking on alternative land when naturally occurring events rendered the felled area unsuitable for stocking. So when we got to the High Court, what SMAR was arguing was essentially that the reference committee's conclusion that the planning regime would be undermined if the appeal was allowed was a plain error, because amending the restocking notice would have had no impact on the planning regime. If planning permission was not granted, then the amendment which they proposed would not take effect. The second ground of challenge was that the minister had made an error in accepting the reference committee's conclusion that replaced felled trees and housing development were both in the public interest, but it was not for them to establish which of those should take precedent. So effectively saying the minister should have formed a view on that. The third ground is that in light of Arnold White, as I've discussed, SMAR had proposed an amendment which was going to expressly allow trees to be felled before the expiry of the maintenance period, which effectively debarred the minister from making that amendment and deciding which of the two regimes should take priority on the facts of a given case. The fourth ground is that the reference committee erred in requiring a wholly silvicultural justification for approving restocking on alternative land, and that the possibility that the restocked trees would be felled again after 10 years was plainly material to the discharge of the Forestry Commission's duty to promote the establishment and maintenance of growing trees. I've described those as the four grounds, but actually they're really the 4 points that the link between the planning regime and the licensing regime as they arose. And in response to each of those points, the court helpfully set out guidance, the first part of which was that the court said there's no sense here in which amending the restocking notice as proposed to allow the removal of trees before 10 years, if planning permission is granted, that amendment would in no way undermine the planning regime, as the restocking notice would remain fully effective unless and until planning permission is granted. The court accepted that effectively the proposed amendment, it did not undermine the requirement to restock in advance of any permission or preempt the planning process in any way, contrary to what was being proposed in Arnold White, which was that effectively the planning permission removed the requirement to restock. Here, SMAR was saying we fully accept we need to restock, we'll plant all the trees, but what they were saying is there may be circumstances that would kick in the grant of planning permission, which then entitle them to sort of end their maintenance earlier than otherwise. And the court actually held that the reference committee's conclusion that the planning regime would be undermined was irrational. Now, Mrs. Justice Levin said if that had been the only ground of challenge, then in applying the standard test of whether the decision would have been highly likely to be the same, she would have found that actually that conclusion wasn't really central to the reference committee's reasoning, and therefore the judicial review may have failed. But what she said was, in the circumstances considered with ground grounds 2 and 3, that was not the case. Now, in respect of ground 2, the court noted that there were factual differences between Arnold White and SMAR. In Arnold White, as mentioned, the appellant had argued that planning permission would remove the need to comply with the restocking notice and effectively trump the felling licence regime, whereas SMAR raised a different question, which was whether a planning permission, or in this case an emerging development plan allocation, was capable of being a material consideration in the imposition of conditions on a restocking notice. And Mrs. Justice Leven said that they were capable of being material considerations, and that the minister had therefore fallen into error by not taking into consideration the public interest in the delivery of houses and the effect of restraining that delivery by upholding an unamended restocking notice. Applying the statutory language as construed in the Witham-Nelson part of the claim, the court accepted that SMAR's proposal to restock an alternative land should have been considered on its merits and shouldn't have been dismissed simply because there was no act of God or exceptional reason why the original land could not be restocked.
Yeah.
So that's quite a lot of material to go through and to summarise on.
Absolutely. So going through it, it sounds like we've got a situation where Arnold White had outline permission. They then felled the trees in accordance with a licence, but didn't comply with the conditions to restock the trees because they got a subsequent grant of their reserve matters. And the Court of Appeal's short point in relation to that was that the outline permission there wasn't enough and isn't going to be enough going forward for people. So in absolute terms, one would need to be alive to what stage planning permission was at the point of felling, understanding that because it's a multi-stage process, an outline permission isn't going to be enough. You'll need reserve matters granted or a full detailed permission to be able to challenge any restocking notice or the terms of a felling licence granted subsequent to the grant of a planning permission.
Yes, exactly. And I think the real addition that these subsequent High Court cases give really is that whilst there's no hierarchy between the regimes, and that's as made clear in Arnold White and as you've said, the fact of a planning permission coming forward down the line or an emerging development plan allocation is nevertheless capable of being a material consideration for a decision maker determining a restocking notice appeal. And so whilst there's not a hierarchy and it doesn't take you into the realm of the exemption, the planning permission exemption, those matters are things that could actually be taken into account. For example, as was proposed in SMAR, in proposing slightly different, more tailored conditions to your restocking notice, for example.
Yeah, so when we're at the stage of either appealing our restocking notice or considering whether the conditions attached to a felling licence are justified and appropriate, what Witham-Nelson and SMAR Holdings primarily are telling us is that things like the availability of other land for replanting will be a material consideration, and that won't be limited only to silvicultural considerations, but will need to have regard, and the reference committee and the minister would need to have regard to wider competing interests of providing housing against protecting trees and amenity in the context that the Forestry Act and the Planning Acts that sit alongside each other. They are equals, they're not hierarchical.
Yes, exactly. And just touching on your point there about alternative land, I think, and thinking more practically as you and Daniel have to what really people need to be doing if they're in these situations is one thing when looking at proposals for restocking our alternative land is whether or not you actually can point to that land. Do you already have the land set aside? Can you say very specifically where you're proposing the trees to be restocked, or are you actually at an early stage of just hypothesizing about it and not actually directly saying where it will be? Because that will, of course, bear on whether or not, even if we now know the Forestry Commission cannot flat out refuse to allow restocking an alternative land, there are still going to be some matters, especially if we're looking at the prospect and a higher prospect of maintenance in the longer term, whether there actually is land in, for example, the appellant's possession or that could be in their possession to allow that restocking to take place elsewhere. Because if that's uncertain, then actually you aren't really in territory of there being a higher prospect of long-term maintenance. So that's something that will need to be borne in mind.
Well, thank you both very much. There's a lot to think about and work through in that. And it seems from what you've been saying that the primary considerations will be to take care with the timing of felling of trees and grants of full permission or reserve matters, and being aware as to whether you are or can fall within the exceptions to felling licence calculations. Understanding that Forestry Act and Town and Country Planning Act sit alongside each other and not in a hierarchical or trumping relationship. And to consider the availability of other land and how your sites and your arguments fit in competing public interests of housing provision and protection of trees and amenity. And I think the final point to underscore and emphasise is that, of course, throughout all of this, evidence is going to be absolutely vital. Jessica, Daniel, thank you very much.
Thank you.
Thank you very much.
And thank you all for listening. Till the next time, goodbye.